Strap in. Today's hearing is a procedural roller coaster where one defendant, Daniel Massey, the court calls the People versus Daniel Mack, tries to swing for the fences on multiple fronts, challenging charges, invoking the Fourth Amendment, demanding speedy proceedings, and, curveball, announcing he's filed a civil lawsuit against the judge and others. The court is juggling two cases across different dates: a July 3rd, 2025 incident with charges like fleeing, charge, eluding, unregistered vehicle, no insurance, DWLS, driving while license suspended, and disobeying a lawful order, plus a March 27, 2024 incident with OWI, third offense notice, felony, DWLS again, and escape from lawful custody. Stakes? Serious. One stream includes felony exposure and potential vehicle immobilization. The other raises a third offense OWI notice that can mean 1 to 5 years if proven. The defendant wants dismissals now, says one count can't stand because he was in a hospital, not a jail, and argues Fourth Amendment violations. The judge? Not biting on oral dismissals, he's steering this into a preliminary examination where evidence and legal sufficiency get tested. Watch for 3 pressure points. 1. What's lawful custody when a hospital is involved? 2. How and when do you raise Fourth Amendment issues? 3. Bond and risk. Can a defendant with prior FTAs, alleged fleeing, and an escape count get out pending prelim? Buckle up. We'll translate the legalese, flag the strategy beats, and keep you ready for the moment the gavel drops, setting a firm prelim date.
Yes, sir. Yes, sir. In anticipation about what I'm going to go through right now, this is absolutely all your fault.
Oh, in anticipation.
In anticipation of it, I'm just letting you know.
Well, let me apologize in anticipation for this being my fault. I am sorry.
Court does call the case of the People versus Daniel Magoo. State your name.
Daniel Magoo.
All right. What are we doing on this today?
Your Honor, I have in regards to case number 25F4-523, I have a couple things I'd like to point out about a couple of the matters here today.
Go ahead.
In regards to count 3, MCL 750197, lawfully detained or imprisoned in jail or confinement. Judging by the definition of the statute itself, Your Honor.
Smart move by the defense to isolate count 3, escape from lawful custody. He cites the statute language and argues the scene wasn't a jail or government confinement, but a hospital, so the element fails. The judge's response is textbook, not now. Whether custody was lawful isn't about the building's label, it's about legal control. Were you detained under authority in the sheriff's agency's custody, or otherwise restrained when you left? That's a facts plus law analysis for the preliminary exam, where the people must show probable cause on each element. Translation, good issue, wrong timing. Engagement, if you're the defense, what evidence would you want for prelim, custody logs, officer reports, hospital guard details, discharge records to prove custody did exist?
It compels us to conclude that one has to be lawfully imprisoned or in jail. Jail being a facility operated by a local unit of government for detention of persons charged. At this location, defendant was located in a hospital and not a confinement by government agency or jail. So I'm requesting that charge is invalid.
That were going to be addressed. That would be addressed at the preliminary examination, sir, as to the sufficiency of the charge. So if you're making a motion that I dismiss it at this point, that motion's denied.
Okay. Further in count 2 and count 1, actually, Your Honor, both of these were, I don't know the procedural process or when it should get raised, but both of them are Fourth Amendment violations. And furthermore, on count 2, MCL 257.904, that the license of the defendant was revoked or suspended given the statute as well, Your Honor, that would require the prosecutor to prove that the license was revoked or suspended at the time of the arrest, and that defendant was notified, and that the defendant operated a vehicle on a highway or roadway. I challenge.
Also swings at counts 1 and 2 with Fourth Amendment talk, suppression land. The instinct is right, but courts are fussy about timing and vehicles. Generally, motions to suppress come in writing with specific facts supporting authority and sometimes an evidentiary hearing. A quick oral ask to dismiss is rarely enough. And remember, at a prelim, the standard is probable cause. Full-blown suppression fights often wait for circuit court after bindover. That said, defense tees up elements on the driving while suspended count. 1. Suspended, revoked. 2. Notice to defendant. 3. Operation on a roadway. Those are clean targets. Pro tip for viewers, prelims are about can the case go forward, not should the case
or roadway. I challenge the prosecutor to prove all 3.
Sir, do you
Sure.
wish to have a preliminary examination in this?
I'm making sure we're prepared for it, but yes.
What'd you say?
Making sure we're prepared for it, but yes, I am. What are the other options? I'm requesting that all the charges are dismissed, a motion for all dismissal on all these charges.
They're not going to be dismissed.
No, okay.
So if you want a preliminary examination and make your arguments, then it might be that they would be dismissed at that point, but they're not going to be dismissed on an oral motion before this.
Ms. Lumby has let me know that all paper discovery has been sent to Mr. McGowan in jail. There are USB drives with video. A number of agencies were involved in the Michigan State Police case to respond to assist. I believe she has obtained all of those videos, and those will be sent interdepartmental to jail staff to serve on Mr. McGowan, and I expect those to be in the interdepartmental mail tomorrow.
Here's the practical clash. The state says multi-agency video and USB evidence is en route. Defense wanted to cross-examine today. The judge threads the needle. No officers present. Discovery still incoming, so adjourned to keep it fair. Defense invokes speedy trial, smart, but a brief adjournment to allow disclosure is routine and usually doesn't violate speedy rights. The win for defense is getting a firm timeline, videos through interdepartmental mail, prelim scheduling within standard windows. Takeaway, demand evidence early and on the record. Engagement, if you were defense, would you push to examine without the videos, risking surprise, or take the delay to study every frame before prelim?
Got it. Okay, so we're not ready. He hasn't gotten the video.
He has all paper discovery, but he does not have all video discovery. I expect that'll happen. So I'm not sure.
So, Mr. McGowan, are you going to have an objection to an adjournment so that you can see all of the discovery that they have prior to setting this for preliminary examination?
Your Honor, I didn't know what hearing I was prepared for today. I was preparing to cross-examine the officers today, with or without the video evidence. So, given that that's not the case and the officers are not here, I would like a speedy trial. I would like to invoke my right to a speedy trial.
So you want your preliminary examination. Those are coming down to the jail to him.
I expected you would have them early next week. So if the court follows its normal setting for preliminary examination, I would expect
I would set it for the 19th, and then
have them in well.
he'd have them well in advance, and I guess I'll do it that way. Prior to setting the preliminary examination as being a critical process, a couple of things that the court wants to do. Mr. Magoo, starting in case ending in 0979. Mr. Magoo, you are before the court on a felony complaint that alleges 5 different counts, fleeing and eluding 4th degree, which is a felony punishable by up to 2 incarceration, $2,000 fine plus court costs. Count 2 is operating an unregistered vehicle, which is a misdemeanor, punishable by up to 90 days. Operating without security, which is a misdemeanor, punishable with not more than 1 year or less than a $200 nor more than $500 fine plus court costs. Count 4, operating while license suspended, denied, and or revoked. That is a misdemeanor punishable by up to 93 days. $500 fine plus court costs, and your vehicle would be subject to immobilization. Count 5 is refusal to obey a lawful traffic order of a police officer. That's a misdemeanor punishable by up to 90 days, $100 fine plus court costs. Those events are alleged to have occurred on July 3rd, 2025, I-94 near Parker Road in Scioto Township. That is on the one case. On the other case, which is a 3-count complaint, that 3-count complaint alleges that on March 27, 2024, location of Dexter near Arcona in the city of Milan, Washtenaw County, state of Michigan, that you did operate a motor vehicle while intoxicated. That's a misdemeanor punishable by up to 93 days, $500 fine plus court costs. There is, however, a third offense notice which transforms this into a felony charge. It's punishable by up to $500 to $5,000 fine plus court costs, 1 to 5 years in jail, probation with 30 days or 1 year in jail, or at least 48 hours to be served consecutively, and 60 to 180 days community service, any rehabilitative programs the court deems necessary. Court could order you to pay the cost of the prosecution, the cost of any emergency governmental services, and your vehicle would be subject to mobilization. Count 2 is
Know Your Exposure aria. The court lays out maximums: fleeing, eluding, felony up to 2 years and $2,000 plus costs, unregistered vehicle and obey lawful order, 90 days misdemeanors, no insurance up to 1 year, DWLS up to 93 days. Then the second case with OE carrying a third offense notice that transforms it to a felony, possible 1 town or 5 years, fines, community service, costs of prosecution and emergency services, and vehicle immobilization. Why does the judge do this now? 2 reasons. 1, compliance with advisement requirements, and 2, to ensure the defendant appreciates the perils of self-representation. For viewers, this is where case valuation happens, what evidence to prioritize, where to seek diversion or treatment, and whether to negotiate.
Count 2 is operating while your driver's license was suspended, denied, and or revoked. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Count 3 is lawful escape from custody, or escape from lawful custody, excuse me. That's a misdemeanor punishable by up to 1 year, $1,000 fine plus court costs. Mr. Groove, yeah, I would just ask, do you still wish on representing yourself, sir?
Your Honor, I do, I will. I have requested assistance given that I am incarcerated and I have no way to.
Do you wish to be represented by an attorney, sir?
I would like legal assistance.
What do you mean by that? Would you like to be represented by?
I've called the prosecutor.
Mr. we go through this every time. So here's what I'm going to do. I'm going to advise you that there are great perils in representing oneself. I've told you about that before on numerous occasions. That I would treat you the same as I would treat anybody else. You would have to know the Michigan court rules. You'd have to know courtroom procedure, and that you would be treated the same. Not any more favorably, not any worse, as you would go through these proceedings. If you wish to represent yourself, you may proceed with the court's admonishment. I've advised you as to the penalty, the charges, the maximum penalties. I will now ask you the question, and I'm not going to just keep going around and around in circles when I ask you this question. Do you wish to be represented by counsel? If you wish to be represented by counsel, this court will ensure that counsel is appointed to represent you. If that is a yes or no.
I would like legal assistance, yes, Your Honor.
I'm going to take that as your request for counsel, is how I'm going to take that.
Classic Ferretta Crossroads. The judge warns that pro-SC defendants get no special treatment. You must know Michigan court rules, evidence, and procedure. After some back and forth over legal assistance, the court interprets it as a request for counsel and appoints the public defender. That's pivotal. With felony exposure, specialized issues, custody status in a hospital, multi-agency videos, and a delay OE third notice problem, having counsel means 1. Written motions with proper authority, CO2, suppression timelines, 3. Targeted prelim strategy, knockout elements, or lock in testimony. Audience question: would you ever go pro se on a potential 1 to 5 year exposure
Is how
case?
I'm going to take them. And so these two cases now become public defender cases.
Thank you, Judge Torsia Feaster, Assistant Public Defender on behalf of the defendant. I believe Your Honor has already agreed to set it for examination.
I will set, he's asked for examination in the case, and so I will set these for preliminary examination.
Good.
Well, Your Honor, I would ask, given that one of these cases, in regards to the March 27, 2024 case, there is an undue delay. It's been over, I think, 390 some days since the warrant was requested, and this triggers due process violations under U.S. versus Levasco, People versus Bassard, People versus Rosengreen, and procedural unfairness, Sixth Amendment violations. And I do request that the prosecutor provide provide information in regards to the three-pronged test under People versus Hernandez. One of them, first test being the explanation for the undue delay for 390 some days. The second part of that test being to prove that the delay was not deliberate. And then the third part of the delay or the prong test is to make sure that there was no undue burden on or prejudice on the defendant. And in that regards, Your Honor, I also am requesting that I do have due process 14th Amendment rights as well as 8th Amendment rights. And a lot of these are facially invalid. A lot of these charges are facially invalid. And I'm just requesting that the court grant a personal
raises pre-accusation delay and due process, citing a roughly 390-day gap on the 2024 case and referencing federal and Michigan cases. That's a real doctrine. Courts ask whether the delay was justified, not deliberate, and non-prejudicial to the defense. He also moves for PR bond, characterizing many charges as misdemeanor level. The judge immediately reframes the risk picture. There's an escape from lawful custody count, fleeing, eluding, and a third offense OE notice, plus an indication he's being held without bond in a separate judge's case. Translation: even if this judge changed bond here, it wouldn't spring him, and on these facts, the court sees flight and danger concerns.
Grant a personal reconnaissance on my behalf, and for both of these charges, being that we're looking at really just misdemeanors, $500 misdemeanors. So
I think he's requesting, Your Honor, amend his bond, and he's requesting the release, Your Honor, PR bond.
In response from the people regarding his bond.
People would ask the bond to continue, and he also, I'm sure, failed to appear before the judge's place. So
yes,
that warrant would also hold up. With respect to the other, I'll wait. If there are pleadings filed by the defender's office, our office will respond to that. And I guess my one remaining point would be, should, with the court's appointment to the public defender's office, I will make sure that the digital discovery that I referenced is served on the defender's office.
yes.
Thank you, Judge. We will review that with our client once we receive it.
So he's asked for a preliminary examination, and I realize where this may be. My understanding is that he is still being held, regardless of what the bond would, in this case, he's being held without bond in Judge Slay's case.
That's my understanding.
That his bond has been denied. So
That's what I
would
Mr. Choda said.
in any event, but also given the fact that one of the charges is the escape from lawful custody, that in and of itself, in this court's mind, makes the defendant a danger for a risk of flight. Also, the nature of the charges, the fleeing and eluding police officers, as well as the operating while intoxicated, now at least alleged his third time around. Also, this court's mind, the defendant, this court would consider a danger to the public. So the extent that he is asking that I modify his bond conditions in his bond in this case,
I have.
That motion is denied. Bond will continue.
Important civics moment. The defendant invokes presumption of innocence, correct and vital at trial, but bond decisions assess risk of flight and danger to the public using arrest history, the nature of charges, fleeing, alleged escape, repeat impaired driving, and any FTAs. The judge expressly finds those risks high and denies bond modification. He also makes a key promise. If the state can't prove the custody element or fleeing at prelim, the charge gets dismissed then. That's the gatekeeping role. The court won't dismiss now on defense's say-so, but will dismiss later if the people can't meet probable cause on each element.
Bond will continue as it is.
Your Honor, I have a 14th Amendment due process to the presumption of innocence. And,
I understand the presumption of innocence.
and a lot of these are facially invalid, Your Honor.
Excuse me?
A lot of these charges, especially the lawful custody, escape from lawful custody, it's facially invalid. I was at a hospital, not a jail.
If you were under the custody of the Washtenaw County Sheriff's
I was
Office,
not.
I understand.
I was not.
Or the custody of.
I was dropped off at the hospital and they later tacked on
And
charges,
you know
just
what?
like the fleeing and
evidence
eluding
will
charge.
not meet that out. And that if that's true, and the people can't sustain that element, then the charge will be dismissed. But I'm not dismissing it upon your representation today.
Thank you very much, Judge.
Preliminary examination in this matter will be set August 19th, 2025, 12 noon. That is before me on that date for both of these cases. I will apprise the parties also that one of the, I will call it one of the activities, and I think it is a maneuver to have the court do something that it normally would not do. The defendant has elected, and I will disclose it, to file a civil claim as against me and a slew of other parties.
Oh yeah, in that regard, Your Honor,
Many of those, do not interrupt me. Including many that I don't even know the connection. Court has, this judge, upon receiving this, two things. I read through the complaint to determine whether or not it would on its face create a conflict with court. I consider it, quite frankly, to be frivolous. The complaint itself, do not see that as a necessity for me to recuse myself from this gentleman's proceedings, because I think that's precisely what he wants to have happen, and that is attempting to manipulate the system. He will be dealt with by me as I deal with any other defendant, and so that is there. It has been turned over to the office.
The defendant says he's filed a civil complaint against the judge and others. The court calls it frivolous, refuses to recuse, and labels it a manipulation attempt, then routes it to general counsel. Legally, simply suing the presiding judge doesn't automatically disqualify them. The question is whether a reasonable person would question impartiality on actual grounds, not just litigation tactics. The defendant orally requests change of venue. The judge requires a written motion and denies the oral ask. Big picture. The bench preserves continuity and authority, sets a prelim date, Aug 19, 2025 at 12 p.m., and keeps the case moving despite the side litigation. Engagement. Do you think suing the judge should ever force recusal, or would that invite strategic judge?
It's there. It has been turned over to the Office of General Counsel for Washtenaw County. They will deal with, for me, and as well as the others that I see that are listed there. They will deal with that. They have also filed, it appears, and again, this is all part of his, what I will call shenanigans to shape this. He has filed against people, individuals without specific reference in the Washtenaw County Prosecutor's Office. I don't, as I view what I read, would not consider that any jeopardy upon their objectivity in handling this case. So,
I'm aware that such filings were being received by our office maybe yesterday. At this point, we continue to proceed with this case until I hear otherwise from the elected prosecutor.
Can I speak on that note, Your Honor?
I will let you talk, but I'm not going to let you go on in some diatribe. I've got other things to do.
I've stood on my rights and I've stood on my beliefs this whole entire time, especially in the previous case, Your Honor. That complaint is well pleaded. It does affect multiple parties of this jurisdiction. Washtenaw County is a named party, and I do believe that my impartiality and bias will be affected here as it was in the past before this complaint. And I do request a change of venue on that note for both these matters.
If you wish to raise change of venue, you may file that in writing, but to the extent you are raising no motion for change of venue, denied.
Thank you very much, Judge.
Bond will continue. Thank you.
Summary. The defense launched early attacks, arguing the escape count fails because the defendant was in a hospital, not jail, raising Fourth Amendment objections, and seeking global dismissals. The court correctly defers all merits disputes to the preliminary examination, where the people must establish probable cause on elements like lawful custody, notice of suspension, and operation on a roadway. Discovery, multi-agency video, is en route. The court balanced speedy trial with a short adjournment to ensure fairness. On bond, the judge cites the separate no bond hold plus flight and danger factors, alleged escape, fleeing, OI third notice, to deny modification. When told of a civil suit naming the judge, the court deems it non-disqualifying, refuses recusal, and orders any venue motion to be filed properly. Next step, prelim on August 19, 2025. PM. That's where elements live or die. Key takeaways. 1. Oral dismissals are long shots. Prelim is the battlefield. 2. Custody isn't about the building sign, it's about legal control. 3. Presumption of innocence coexists with risk-based bond decisions. 4. Suing the judge rarely forces recusal without real grounds. CTA, if you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom
We'll
breakdowns.
continue. Thank you.
Somebody be able to continue.
Appreciate it.